Chapter 4, drafting of agreements, deeds and documents. Though contracts, deeds, etc. can be oral, written or implied also. However, it is also always preferable to enter into written contract, as it is always difficult to prove the terms of an oral or implied contract than those of a written one. So some of the benefits of having a written contract are: first, the process of written down the contract's terms and signing the contract forces both parties to think about and be precise about the obligations they are undertaking. With an oral contract, it is too easy for both to say yes and then have the second thought. Only one thought will be, and consciously what they are into, they will be aware of. So next, with an oral contract, the parties may have different recollections of what they have agreed on, just as two witnesses to a car accident will agree over what has happened. A written agreement eliminates disputes over who promised what. So eliminates the disputes. Some types of contract must be in writing to be enforced. Copyright Act requires a copyright assignment or exclusive license to be in writing. So some of the contracts require to be in writing to enforce. If you have to go to court to enforce contract or get damages, a written contract will mean less dispute about the contract terms, as a burden of proof lies with you. So I have a burden of proof burden of proving the proof. So written contract, if it is there, it will be easy to me to prove. Points to be kept in mind while drafting a agreements. First, prepare an outline, that is synopsis. Establish a single principle of division and use that principle to divide the subject matter into topics. Arrange the topics in a logic sequence. Give appropriate headings. Remember the audience in mind when drafting an audience. So give appropriate headings. Arrange in a term logic sequence. Remember the audience in the mind when drafting on a document. The text should be clear writing. Use concrete word and be concise. Avoid gender specific words so far as possible. Write in a short sentence. Use proper punctuations. Avoid drafting in passive and use active voice, as it is more direct and vigorous than the passive. As far as possible, put statement in a positive form and make definite assertion. Assertion means declaration. Avoid unnecessary hesitating and non-committal language. Means no commitment, that I will do, like that will not be no non-commitment. Express coordinate ideas in similar form. Keep related words together, as position of the words in a sentence is the principal meaning of showing. In summaries, keeping to one tense, especially the present tense. So in present tense should be emphatic words of a sentence should be placed at the end. Document meaning. Document denotes a textual record. Increasingly sophisticated attempts to provide an access to the rapidly growing quantity of available documents raised questions about which should be considered as a document. The document, in very similar terms, document means any matter expressed or described upon a substance by means or of letters, figures or marks, or by more than one of those means intended to be used or which may be used for the purpose of the recording that matter. First, a writing is a document. Words printed, lithographed, photographed are a document. A map or a plan is also a document. Inscription on a metal plate or a stone is also a document. Caricature is a document. So 5 things they gave. And according to general classes and according to IPC also, they have defined the document and how to draft a document. The following 10 easy and important steps can be followed for drafting. First, ascertain a proper title of a document which aptly describe the nature of transaction. So now we are into sale of a property, but title is mortgage of a property. What link is there? So first, ascertain a proper title which aptly describe the nature of the transaction. By seeing title itself, we can go to the covenants also directly. Say we can think of what and all will be the covenants, like description of the property, parties, consideration, advance if any, registration, dispute, default, all we can think of it. Ascertain the parties to the transactions or agreement. Ascertain the parties to the transaction or agreement. So party should be ascertained, or the person executing the document representing the party. So ascertain the parties first. The particulars of identity like father or husband name, residential or office address. So first ascertain the parties and their identity also, father or husband name, residential or official address, age, date of incorporation. In case of company it should also be mentioned. So first we'll write the title, this date is executed, first sale date, this date is executed so and so, and after whereas this sorry this deed is executed by and between A son of resident of, B son of resident of, will be that only they are saying. Second point. And note down the transaction or agreement and the consideration involved. So note down the transaction or agreement, which type of transaction are we into, and what is the consideration involved. In case of a gift, no consideration. In case of a sale, there will be a consideration, and in case of a merger, consideration will be shares plus consideration, like that. The state, the mode and manner of a payment of consideration. So mode will be cash and kind. Manner may be online or offline. Note down the various terms and conditions of the agreement. Terms and conditions will be noted down as a covenants. This terms actually states the right and liabilities of each party under this agreement. This term should be drafted in a very clear and precise language. Clear and precise language. The words should be unambiguous so that the only one meaning or interpretation is possible. It should be ensured that no condition is left out. Means all should be covered, and it should be precise, and unambiguous should be. At the end, the document should be bear signature. So how to draft a document means, like how we'll draft the document, that only we have to write here. That's all. Such document also required to be witnessed. So we'll write witness 1, witness 2, no, that only. Where a document is required to be executed on a stamp paper, then the stamp paper should be of a prescribed value. So that also we can prescribe. And if a document is required to be registered, should be represented for registration before the appropriate authority within a reasonable time of its execution, that is 4 months. And necessary number of copies of a document should also be prepared on a stamp. Type of agreements: business agreement, documents for formation of an entity, ADR, property related documents, IPR related documents, cyber law, banking and labor and employment, and deed of power of attorney. And before that, there are types of agreements. First, business agreement: acquisition, agency, advertising, consultancy, construction, distribution, franchisee, foreign collab, hire purchase, investment, joint venture, service agreement, shareholder agreement, stock purchase, sale, technology sharing, agreement to act as a technical or management advisor, agreement to supply technical know-how, technical collab, agreement between manufacturer and sole selling agent, appointment of sole selling agents by a foreign company, agreement for underwriting shares of a company, underwrite debenture stock, agreement between company and its manager, agreement between a company and the security service company for providing security services to company, property, brokerage agreement, agreement between a firm and a broker for agency, agreement between manufacturer and commission agent, dealership agreement, deed of indemnity by the partner retaining assets and liabilities to a partner on a dissolution of partnership firm, indemnity for loss of allotment letter, indemnity by a debtor to his guarantor, and for formation MOA, AOA, partnership deed, LLP, trust deed, conversion of partnership to LLP, association of persons agreement, section 8 company, MOA and rules and regulation of society, ADR, agreement for reference to sole arbitrator, agreement for reference to common arbitrator. These first two we have the draft also. Model arbitration also we have, model conciliation clauses and model mediation clause, mediation agreement also we have as a draft. Appointment of a sole arbitrator on default of other party, agreement for reference to arbitration between the parties. Property related: purchase of flat, house, apartment, purchase land, leave and license, license authorizing the license to use a part of a land of the licensor as way of house of the Licensee, development agreement, transfer deed, POA, lease of building or office, lease of agricultural land, lease of furnished house for residential purpose, deed of surrender of a lease, deed of renewal of lease, tripartite lease agreement, that is three parties, lessor, lessee, guarantor, sublease, modification of the terms of lease, gift deed of property, partition deed, settlement, construction, rent, sale or purchase, agreement to sell, deed of mortgage of property, relinquishment deed, surrender deed in cooperative housing society, simple mortgage deed, conveyance, deed of mortgage by a conditional, by a deposit of title, and deed creating charge on the property, IPR related all, patent, license, know-how, joint development agreement, software development agreement, technical know-how, use of copyright, agreement relating to protection of design, trademark, patent and know-how, use of trademark, cyber law, software service, internet service, privacy policy, software escrow, website development, internet gateway, technology related, banking, loan, bank guarantee, promissory note, LOC, reimbursement account, agreement, indemnity given to bank for issue of duplicate bank draft, indemnity given to bank by the natural guardian of a minor children, indemnity for loss of deposit receipt, employment agreement, non-disclosures agreement, compensation, collective bargaining agreement, wage, employer and employee, and refers dispute to arbitration, contract labor, agreement for appointment of MD, on the job training agreement, for private equity funding, business plan, term sheet, warranties, indemnities, disclosure letter, shareholders or investors' rights or subscription agreement, and other legal affidavit, plain written statement, and notices. Notices are very important for examination point of view. Read thoroughly every notice. Power of attorney, general power of attorney. Power of attorney, attestation is not compulsory but can do. POA is an instrument whereby specified person or persons are empowered to act for and in the name of the person executing the instrument, that is donor. Power of attorney are specifically or identically referred to several statutes. It is a type of agency and law relating to the power of attorney, forms part of the general law of agency. General power of attorney. General power of attorney is a type of deed poll, POLL, so executed by the single person. So I format, I. If deed pool means two or more, so two or more copies will be given. Here only one copy is required. General power of attorney, I am giving authority to all the acts by the passing this general power of attorney. So where the instrument is executed generally for certain acts, it is called general power of attorney. If POA authorizes the agent to act generally on in more than one transaction in the name of the principal, it is known as general power of attorney. However, the general means the power must be general in respect to the subject matter. So I format will be used. I format in first line, to all to whom this present shall come, or know all the men by this present, to know all the men by this presents, that I, Mr. A, son of Mr. B, resident of Delhi, at present residing and address, do hereby appoint Mr. C, son of D, residing at A, to be attorney for me and in my name and on my behalf, so to be attorney for me and in my name and on my behalf, whereas I own various movable and immovable in various parts of the India described in the schedule. So whenever property related comes, described in the schedule, and at last we can write after the all witness signature and all of that all done, we can write a schedule. In schedule, the Mr. building is situated at and consists of dash and north, south, east, west, like that is a schedule. And whereas I presently residing out of India, as mentioned here in above, for the time being I am personally unable to attend to my day-to-day affairs, and for the reasons for inconvenience, it is necessary that I should appoint an attorney and confer upon him the powers herein stated. Know all by these presents that I, the said dash do hereby nominate. So I am Mr. A, do hereby nominating and constitute and appoint Shri Mr. B, son of late, at present residing at, as my lawful attorney for me, in the name and on behalf of myself and or my said attorney, and in any of my said capacities, and in the name and on behalf of the any partnership, firm, association, trustee. So anyone can do this all power of attorney, general power of attorney, and he will do the things, namely first commercial, to buy and sell the property, and to contract for any new to enter into sign and partnership business, to transact business, property, to acquire the property, and to manage and maintain, to receive the any rents if owner has given the rent for rent purpose, and to get the utilities, whatever if we wish that 3-4 points we can write. Companies, to promote the company, to promote the company means if we promote company only, now we'll get more profits, and our company will go into the public. So to promote the company, and to spend money in the promoting a company, to contract to take the shares, to apply for and accept and deal with the shares, to consent to act as a director, to exercise shareholders privileges, to transfer the securities, to receive the bonus shares and other benefits. Investment, to sell investment, to purchase investment, 2 points. To initiate the proceedings, to pay all the call money, and to apply for contract for investments. Banking, to do all the banking related operations, and drawing and negotiations of the check and next bill of exchange, to deal with the bill of exchange. Money, to realize money or money, borrow the money, loans and advances. Miscellaneous representation, to represent before banks or banks, insurance companies, etc. To prepare, sign and file tax returns, appear before assessing officers, to appear before registrar, notary public, magistrate. Why we need to appear before registrar means to get property registration or any companies related, if say resolution is passed, to file INC 28 and all. And if any merger want to take, then also should appear. So and so many reasons will be to appear before registrar. And trust, to execute the trust, to exercise the powers of the trust, and execution and registration of the documents, whatever documents relating to the that power of attorney giver, this power of attorney holder should execute all the deeds and register the deeds. Legal proceedings, to all to conduct and defend the legal proceedings, to appoint the advocates. So for legal proceedings we should appoint advocates, that, and to sign the plaint, to deposit and receive documents from the court. Sometimes we have to give our side of point of view, so we have to deposit and receive also. Receipts and discharges, receive money and goods, to collect the debt, if on credit basis any sold goods, to receive the collect the debts, and to give the receipt, to receive debts, gifts, legacies. Agents, agency, like principal and agent, as them also, if we gave our business products, agency, to employ persons in any capacity, to employ the professional if required, like a listed company required CACS and all, so to employ the professional. Miscellaneous, to enter into bond and indemnities. Over means majorly all of the activities of Mr. So and so will be done by Mr. So and so. I hereby giving the authority for him to act. And at last, in witness whereof, I dash herein set my hands and dash signed and delivered and within named witness 1 2 identified by before me advocate and notary public. Schedule 1 referred to schedule means if you have more properties now, so more schedule, how many properties will be, that many schedules will come. Special power of attorney, if an instrument is executed for a specified act or acts, it is called special power of attorney. A power of attorney conferring on the agent the authority to act in a single or specified transaction in the name of principal is known as special power of attorney. So for the purpose, for the single one purpose for which I gave, for that only be restrict yourself. Like if I have a property, I want to sell that property, I directly can't sell, so I gave power of attorney to Mr. A. So Mr. A will advertise on behalf of me, and if any buyer approaches, he will negotiate and fix the prices, and prepares the sale deed and put terms and conditions in the sale deed and take care of a registration and stamp. So on my behalf, Mr. A will take care all the things related to sale, So by this power of attorney, I dash son of dash residing at do hereby appoint Mr. Dash son of and residing at dash to be my attorney for me and in my name. So to negotiate and sell my property situated at to any purchase at such price and such time as may be said by the attorney, may be in absolute discretion think proper to give so generally they are saying to sell my property received at so and so place, and more specifically mentioned in the schedule to receive from the purchaser the consideration money for the said property and to give receipt of the receipt and discharge thereof as may be required. So if if purchaser buys the gives the money, money receipt should give that to deliver physical possession in the manner that is possible in the circumstances of the said property, to apply the municipal corporation of for mutation of a said property in favor of and in the name of the purchaser. So legal work what and all is that also, and I hereby agree and undertake to ratify all the acts, deeds, assurances done, given, executed or made by said attorney under the powers conferred by power of attorney as if were done by or made by me, in witness whereof I dash have hereinto set my hands this date and day of signed and delivered. Witness 1 2 identified by me and before me advocate. Lease and license. License means just a permission, like driving license, it is just a permission to drive on the roads, doesn't mean it is a permission to do accidents also. So it is just a permission or a right given to you, just enjoy the property, that's all, you cannot do any changes in it. Whereas lease, yes, right to enjoy and actual possession will be given to you so that you can do any changes also, provided once you have to inform to the owner. Lease of a movable property is a transfer of a right to enjoy such property made for a certain time. So lease is for certain time, express or implied or in perpetuity, in consideration of a price paid or promised, or a money or shares or services to be rendered periodically or on specified occasions. Lessor and lessee, premium and rent. So transferor is called the lessor. So the owner is called the lessor, and to whom the property is giving at a lease is called lessee. The premium price is called premium amount. Means for normal we'll say rent amount. Here premium. The money or share, services or other thing so called render is called as rent. So rent can be in the form of direct money, share, service or other things. Lease, how made? All the lease of immovable property from year to year or any term exceeding 1 year. If term exceeding 1 year, registration is compulsory, or reserving a yearly rent. Then only if reserving a yearly rent, then also registration is compulsory. Can be made only by a registered instrument. All other leases of immovable property may be either by a registered instrument or by a oral, because it is not compulsory to get registered. Year to year, exceeding year, yearly rent, these all lease agreements should register according to the Registration Act. Where a lease of immovable property is made by the registered instrument, such instrument buys both lessor, that is owner, lessee, that is the tenant person. Essential elements of a lease. First, read carefully this, because these 5 points only will be in the draft also. The parties to a lease are the lessor and lessee. The lessor is called the landlord and the lessee is called the tenant. Subject matter: so and so property is situated at so and so place, and I am giving the may not be only you a house, land, but also benefits to arise out of land, right to collect fruit of a garden. So everything of my property is now for you only, you can do whatever you want. I have a garden, you can take fruits from it, and right to extract coal or minerals, anything, if fisheries, that also. And duration of a lease as decided by them, that may be perpetuity or for a certain period. And consideration, either premium or rent, which is price paid or promised in consideration of the demise. The premium is consideration paid for of being let in possession. So why the premium is paying? For letting to be possession of my property to you. Sublease, sometimes sublease is allowed, sometimes sublease is not allowed, so that also should be mentioned. Okay, lease deed. This lease deed, so title, next, by and between Shri, son of and dash. So first owner, that is landlord, will come. So first lessor, son of, and that all will come. And next lessee. and whereas the lessor is in the complete possession of the building bearing municipal number situated and more particularly described in the schedule given below. On the request of the lessee, the lessor has agreed to grant a lease in respect of the demised premises for a term of how much term they have agreed, that much term. And now this deed witness it as under. So first description of the property, where the property is situated and all, and possession of the property. Possession will be transferred and not the ownership, only possession is transferred. Term as they decided the term will be normally for lease term is 11 months. So if they want to extend with the both consent, they can extend. Consideration, rental and rental any form can pay, no? So even shares also we can add. And terms and condition, the said plot of land shall be used strictly for the agricultural activities only and no other commercial activity. The property shall not be sublet. So sometimes in terms and conditions this clause may not be there because the owner is okay with the sublet. Cost and charges, stamp duty, registration, property taxes and all the owner has to bear, because rest the legal costs to execute this agreement shall be borne by the lessee. Equally should bear now. Termination. If any of the provisions or terms and conditions are breached, the termination may happen. And if the lessor or lessee, if either of them want vacation, so 3 months advance they should inform, either of the party should inform to another party. And default, if lessee did any default, then can forfeit the advance money. That in case of a lessee default, normally we have to write if either of the party makes a default, either the other suffering party is eligible to compensation. But here we know who can there where is the chances of getting default. So specifically here we can mention for normal means other than this, be like general we can write the suffered party has to get the compensation from the other party which done the losses by not performing the contract. That in case of a lessee default in payment of monthly rentals or any term of this deed, the lessor shall have the right to terminate this agreement by giving 3 months notice. So even if he not complied with the terms by making default in the monthly rentals, lessor has to give 3 months notice to ask him to vacate, and the amount due rent and any loss shall be adjusted against the deposit amount. So 3 months due is enough, that can be adjusted from the advance he given. And any dispute, either court or arbitration, where however they want they can decide. And schedule to the agreement. Schedule. This can be written in description as well, but it to gain the more marks at the end of the draft, if we write, we'll get more marks. Even it will look good and the length of the will be more. The property as described in the agreement is a plot of land at measuring about 10,000 square feet, having plot number dash, and is surrounded by the following properties towards north, south, east, west. North, south, east, west. First 5 words, next 4 words. 5 words is north, south, 4 words is east, west. In witness whereof both the parties to this agreement have joined their respective hands on the date mentioned above to give effect to this agreement. Signature, name, signature party of the first part, signature party of the second part, witness also, name, address, signature. Done. Leave and license. Leave and license. In this, constructive possession will be given, no actual possession. Means if tenant will get the actual possession in the lease, because he can make any changes, he can use all the property and any garden also. But in license it is a constructive possession, only right to enjoy, that's all. Means we went to the hotel, can we do any changes in that, like curtain is not nice, so remove this, mirror is not nice, remove this, can we make? No, just we'll go, we'll dine in and we'll come off, that's all. Like that, just constructive possession. In a license it is just a right to use the property. And license is defined under section 52 of the Indian Easements Act, when one person grants to another or to a definite number of other persons right to do or continue to do in or upon the immovable property of the grantor something which would in the absence of such right is unlawful, and such right does not amount to easement or interest. So interest in the property will not be transferred in case of license, whereas in lease interest will be transferred of the property. Next, leave and license agreement. This agreement of a leave and license is made on dash date and dash between two persons, that is first licensor and then licensee, and whereas the licensor has a sole director of the company which owns the office at so and so, and whereas the licensor are the thus absolute owners of the said office and accordingly absolutely entitled to use, occupy, possess and enjoy the said premise, and whereas the licensee has approached the licensor and requested that licensor to let out it, the licensee the said premise on leave and license basis, which is the licensor have agreed to on certain terms and conditions mutually agreed upon between them, and whereas the both the parties here to desirous of recording the said terms and conditions. Now this agreement to leave and license witnesseth as it is hereby agreed by the parties hereto as under. So now the just I read one line. This is called testatum. And there is a case law of Chandulal versus Delhi Municipal Corporation. In that you can know better like difference between lease and license. Go through it once. So specimen of leave and license. So first description of the party as usual and right to use. So here only possession in license in lease possession has been transferred to the lessee, but here neither possession nor ownership will be transferred, just right to use the property will be transferred. It is simply on usage basis, that's all. Term 11 months generally, and consideration that monthly rental of so and so amount on every fifth day of next month. Terms and conditions. The said property shall be used only for residential purpose and no material alteration. So alteration is the main clause here. No alteration is allowed. Cost and charges will be borne by the licensor, while the maintenance cost borne by the licensee. Legal cost to execute the agreement shall also be borne by the licensee. So in both the cases, licensor will bear licensor and lesser, both will bear only registration or municipal taxes. Rest all cost and legal cost should bear by the tenant itself. And default, if licensee commits default in payment of the monthly rentals, he shall be liable to pay interest of 10%, 18%, 12%, whatever for the delayed period, and deposit amount in such cases, and deposit amount shall be forfeited. Dispute, if dispute arising can be referred to court or arbitration, and in witness whereof this clause is called as and at last formal part, close, signature, name, party of the first part, signature, party of the second part, name, witnesses. Next, mortgage. Borrower, what is the last word? Borrower, ER. So mortgager, last word R. So R. Mortgager is the borrower. And bank, that is mortgagee. Borrower is a mortgager, and the opposite party, that is bank or financial institution, is called as mortgagee. So in this agreement, first who will come? Whoever giving the property. So who is giving here? Borrower, that is mortgager is giving. So mortgager will be first name. Mortgager or company or transferor will be the first person, and second mortgagee, transferee, party of the second part. There are types of mortgages: simple mortgage, conditional mortgage, usufructuary mortgage, English mortgage, mortgage by deposit of title deeds or equitable mortgage, anomalous mortgage. Simple mortgage, first the deed is executed so and so between so and so, first mortgagor will come and second mortgagee will come, because property is getting transferred from mortgager, that is borrower, to the financial institution or bank, that is mortgagee. So the mortgager is absolutely seized and possessed of or otherwise well and sufficiently entitled to the house bearing situated at dash, and whereas the mortgager has requested the mortgagee to lend him some rupees, the mortgagee agreed on the mortgager by mortgaging his property. So in pursuance to said agreement and consideration of the sum of rupees at before execution of these partners by the mortgagee to the mortgager. So here he want the loan and bank want the property. So here we go. And mortgager after and also has to pay the interest. So interest rates and interest rate also will be fixed per annum from the date of present till, and any installment should be paid in full and within due date should be paid. And this date further witness it as the mortgager do hereby transfer by way of a mortgage his house bearing and house details per annum, with the condition that the mortgager, his heirs, executors, administrators or in assigned shall on the said day pay the mortgagee his with interest thereon at the rate mentioned upon the request. So property related anything should be written, and it is hereby agreed and declared that the mortgager does not pay the said mortgage amount with interest when shall become due and payable, that if under this present the mortgagee shall be entitled to sell the said house. If he fails, the mortgagee can sell house and through the competent court and to realize and receive the said mortgage amount and interest out of that sale proceeds by the mortgager, during the period the mortgage amount is not paid and the said house remains as a security for the mortgage amount, the mortgager shall insure the said house and take out of an insurance policy in the joint name of a mortgager and mortgagee, and continue the said policy in full force and effect of paying premium, and in case of a default by the mortgager to insure or to keep the insurance policy in full force and effect of mortgagee can insure the said house, and premium paid by the mortgagee will added to the mortgage amount if not paid by the mortgager on demand. So if anything he not pays, it will add on to the loan amount. And it is further agreed that mortgagor can grant lease of the said house with the consent of the mortgagee in writing. That he shall bear stamp duty, registration and other out-of-pocket expenses for the execution and registration of the deed and reconveyance deed, but however each party will bear cost and professional charges of his advocate personally. And in witness whereof the parties have put their hands the day and the year first year hereunder written, the schedule above referred to, signed by the above mortgager and mortgagee, name signature detail, witnesses, name signature details. Deed of mortgage by conditional sale. Above details are remains same. So from vendor, first party is the vendor, hereinafter called the and the second other party is purchaser. Whereas the vendor is seized and possessed of or otherwise well or sufficiently entitled to the land and premises situated at and more particularly described in the schedule, and whereas the vendor is in need of money and requested purchaser to advance him, so vendor want money, so vendor is giving his property, so vendor is the first part, and my purchaser, that is he is giving money, so he is the second part, to advance him sum of money which the purchaser has agreed to do on the vendor agreeing to execute this deed of sale in favor of a purchase in respect of the said property in the manner following. Pursuant to the said agreement and in consideration of the sum of paid by purchaser to the vendor, the execution of these presents, receipt of various receipt whereof the vendor doth hereby admit, he vendor hereby grant and convey to the purchaser all the said piece of land. So he is giving land and building, land with building to the purchaser for the money advanced, and that is situated at dash and more particularly described in the schedule, and all the things permanently attached there to standing and all, means property related all they gave here. Next, hereby agreed and declared that vendor shall at any time hereby after repay the purchaser in dash years within dash period the grant and the transfer of the said property provided shall become void, and the event the purchaser shall retransfer the said property to the vendor or his legal heirs, means if he makes all the payments, property will be returned back to the vendor. Provided, however, it is agreed that vendor or his heirs or shall fail to repay the amount within a set period, and transfer of the said property of the purchase hereby shall become absolute in favor of the purchase. So, if vendor fails any in repayment or so and so, property becomes purchaser's property, and the vendor doeth hereby with the purchases that enter into the covenants with the purchases that vendor has a good right, so good right and full power to grant the said land. So he is owner, real actual owner, that in A point. And B, that the purchasers shall quietly possess and enjoy the said property and receive the rents, income and profits thereof without any lawful interruption or disruption whatsoever by the vendor. So now the property possession is with the purchaser, so he'll receive all the rental income and all from the arising from such property, and the said premises are free and clear and forever released and discharged otherwise by the vendor will be sufficiently saved and kept harmless. So no any encumbrances or interest or anything should not be there of vendors. It should be free and fully for the purchaser itself. That the vendor and all person claiming estate or interest of the said premises shall and will from the time to time at all times upon the request purchaser at all the cost vendor to do execute or such all acts, deeds and things whatever more perfectly assuring all or said premises onto and use of purchaser in the manner. Okay, means normally he cannot claim. So vendor and all person claiming any estate or interest in the said premise under him shall and will from time to time at all time receive upon the request of the purchaser and a cost of the vendor to execute or cause to be done or executed all such act and deed and things whatever for the further perfectly assuring. So if they want to claim the estate or interest as purchaser mentioned that all they should follow in witness whereof and schedule and witness over. Gift deed. Gift. According to section 122 of TOPA, gift is a transfer of certain existing movable or immovable property made voluntarily. So voluntary is the most important thing here. Voluntary and without consideration. So it is an exception to the in the contract act. It is an exception to like consideration is important to enter into the contract. It is an exception. Gift is an exception. Without consideration also we can enter into the contract. By one person called the donor to another called the donee. So donor, O-R, gives to donee. He will accept, donor will give, and accepted by on or behalf of the donee. A gift is a common mode of transfer of property. It is a transfer of certain existing movable or immovable property by one to another. The transfer should be made voluntarily without consideration. The essential elements of a gift are, and keep in mind, like in the question if comes in a professional relationship, the gift is being exchanged. So you cannot use the word love and affection. If professional capacity, esteem and regards, this word we have to use. Esteem, in the esteem and regards, professional A is giving gift to professional B, like CA is giving gift to one more CA or one more CS in the esteem and regards. If it is a nearer relation, personal relation, love and affection will be used. Essential elements. First, it should be voluntary and without the consideration. Donor is a person who giving, and donee is a person who accepting, and acceptance is the important thing. Without accept, gift is not valid. The person accepting the gift is a donee, and all persons with whether sui juris are not competent to receive gift. Means competency will not be checked. Even for minor, anyone we can give the gift. A minor can accept the gift other than gift is onerous. So minor cannot accept the burdensome gift. Competent to gift. So donor should be competent enough to make the gift. And a gift by a minor is void. Competence to contract is important qualification required to be making a gift. So to accept a gift, okay, but to make a gift should be competent enough. Subject matter of a gift: all property, real, personal, corporeal, incorporeal may be subject of a gift. A future property or mere expectancy such as expectation of a succession to the property as a possible hire or cannot be transferred. So in existence actual gift should give. In future I'll get a 1 crore, that I'll give the gift for you. What is a guarantee, bro? You'll get 1 crore. Now present what you have, that you have to give me. That is a gift. The mere chance or uncertainty, that all will not come as a gift. Present with you have the property, gift that comes under the law. And transfer, the donor should transfer the property voluntarily and without consideration. I'm blackmailing you to give me a gift, or like we'll do on the Rakhi. That is not a gift actually. So it should be done voluntarily without the consideration and with love. Acceptance, the acceptance of a gift should be made by the donee. So acceptance should be is important. Like for donor, competence is important na. If he is not competent enough, he cannot make a gift. And for donee, acceptance is the important. If donee is not accepting the gift, he cannot receive also, bro. Sorry. And in N.M. Thakkar versus P.M. Thakkar, it was held that the execution of a registered gift deed, acceptance of a gift and delivery of a property together make the gift complete. So, execute of a registered gift deed and acceptance is only will make fulfill the gift deed. How gift or of transfer is affected? For the purpose of making a gift of a immovable property, the transfer should be affected by a registered instrument signed by or on behalf of the donor and attested by at least two witnesses. And in Gomti Bhai versus Matula, it was held that mere intention to give away the property is not enough to the effect of transfer of gift. There has to be registered gift deed in order to gift the complete in the eyes of law. So registered gift deed is also important. And there are two deeds, deed of gift of movable and immovable. Movable is smaller one and immovable is the bigger one. And deed of gift of movable property is not actually compulsory, and immovable is compulsory, and it should be registered, and stamp duty also should be paid by the donor and compulsory to register, and movable is not compulsory to register. So I, that is donor, residing at so and so, do hereby make a gift of ornaments, that is gold and jewelry specified in the schedule herein under the written, to my daughter Miss Dash, in consideration of natural. So if in a professional, here see, father and daughter, so that is what personal capacity. If professional capacity comes, like I am gifting to my employee, employer is gifting to employee, then what comes under written, to my employee Mr. So and so, in consideration of esteem and regards on the occasion of his birthday, marriage, whatever. Signed by the donor, donee, witness. Witness is two witness should be there. Deed of gift of immovable property. This deed of, and one more thing, we cannot assume the facts, like this is the deed as it is, how they are given the dashes and all, like that only we have to present in the exam. Provided if they ask us to assume the facts, we can assume, and if they directly give the facts and ask, we have to incorporate those points given and then only should draft. Without incorporating the what they have given, that also chance of losing marks. And simply we cannot assume directly. If they ask us to assume the facts, then only we have to assume, or else now how the deed is given. I, Mr. Dash, residing at Dash, to hereby Dash, to daughter Dash, Miss Dash, like that only we have to write. Signed by the donor and accepted by the donee and all. And at last we cannot sign, we should just write whatever given in the question, like Mr. A only we have to write. We should not write our own name, keep in mind. Like if we write our name, we are disclosing our name in the paper. This is not as per the code of conduct of ICSI. Deed of gift of immovable property. This deed of gift is made on dash between first donor, because donor is giving now. Whoever gives, that person will be first part in all the deeds. Like mortgage we have done. Who is giving the property? Mortgager. To secure his payment, to get the money as a security, he is giving to the mortgagee. So who is giving property? Mortgager. So first mortgager. Here who is giving the property or ornaments? Donor. So donor will be the first, and who is receiving? Donee. So whereas the donor is seized and possessed of a land and premises situated at dash, more particularly described in the schedule. Donor is related to donor as dash. Donor desires to grant the said land and premise to donee as a gift in consideration of natural love and affection. So, natural love and affection means it is a personal relation. Donee has agreed to accept the gift as is evidenced by his executing these presents. The market value of a said property is estimated to be dash. Now this deed witness it as that the donor, without any monetary consideration and in consideration of natural love and affection which the donor bears to donee, hereby grant the transfer way of gift said land and premise situated at dash and more particularly described in the schedule hereunder, written together with all the building structures thereon and all the things permanently attached thereto or standing thereon, all the liberties, privileges, easements, advantages thereto, all the estate, right, title, interest, use, inheritance, possession, benefit, claim and demand, whatever of the donor to have and to hold the same on to the use of donee absolutely, so absolutely, but subject to the payment of all the taxes, rates, assessment, dues, duties now hereafter chargeable thereon the government or other local authority. And donor hereby covenants with the donee that he is a real owner, rightful, powerful authority, and donate all times hereby peacefully and quietly occupy. So once I gave the gift, all the properties of you only, I'll not interfere in between. That is the second point. And third, the said land premise are free and clear, freely and clearly, absolutely released and discharged or otherwise by the donor, and will sufficiently saved, kept harmless and indemnified from the against all former estate title charges encumbrance. Means before giving the gift, if any charges or any liability pending on the gift property, that all have been cleared. And further that the donor and all the persons having lawfully claiming any estate or interest whatsoever to the said property thereof request the cost of the donee and do execute or cause to be done and executed all such future and other acts whatever or better and more perfectly assuring the land and every part thereon and to the use of donee in the manner aforesaid executors and assigns reasonably required. Means from all the perspective, donee will be the absolutely owner, no one will interfere, and lawful claim also nothing will be done, or fully completely he can enjoy the property donee. In witness whereof the donor as well as donee by way of acceptance of a said have put their respective hands the day and year here mentioned, the schedule referred to, signed and delivered by within the name of the donor has to sign with by name donee and two witnesses. Sale deed and agreement to sell. Sale deed acts as a main legal document for evidencing sale and transfer of ownership of property in the favor of buyer from the seller. Further, it also acts as a main document for further sale by the buyer as it establishes his proof of ownership of the property. First, it is a evidencing that the seller is a real owner, and from real owner only I am buying the property. Further, if the buyer want to make a sale of this property, the other party also can be sure that actually he is the owner and he is the right owner, for we can receive peacefully. So the specimen agreement for sale of house. So agreement for sale of house. This agreement made a dash and dash between first seller, because from seller only property is going. So seller and second party is the purchaser, that the seller agrees to sell and the purchaser agrees to purchase of the sum so and so house owned and possessed by the seller as an absolute owner and situated at dash, containing add measurement dash square meters together with all the building fixtures, furnitures and all etc. And this clause is the consideration clause, and the sale deed executed on or before day whereupon the purchaser shall be entitled to immediate possession of the property sold to him. So immediate possession will be given, and the seller shall guarantee his sole and absolute title. So about title, seller is giving guarantee, and purchaser sold is free from the encumbrance, and the property is all free from the encumbrances. if any also, shall be discharged by the seller before transferring to property to the purchaser. And within 2 days from today, the seller shall produce all the title deeds. So to prove his title, he shall submit the all title deeds for the inspection of the purchasers of its nominee. And next, even purchaser also will deposit the earnest money. If anything found default, the earnest if anything found default on the part of the seller, purchaser can ask for payback of earnest money deposit. And all the taxes expenses relating to property are up to date, and completion of the sale shall be paid by the seller, and thereafter by the purchase. Till the date of purchase, seller has to be clear with all the payments related to taxes and all. He should make all the clear payments of the property. And that if the seller makes default in the performance of the condition, he shall pay. So damage, if seller make default, so and so amount, if buyer makes default, so and so amount has to pay the compensation each other. And the expenses of the sale shall be by the seller or purchaser as agreed, or if not agreed anything, equally shared. That the title deed of a property shall be handed over to purchaser by the seller at the time of completion of the sale. So on completion, when the seller receive money, when at that time only he will give the property ownership papers or title deeds. That this agreement shall bind above parties and their respective heirs and representative as well. That if there is any difference or dispute, they can go to the court or arbitration. Here they gave arbitration. And witness will be two, signature of seller and purchaser, name and designations of the signatories, that is seller and purchaser. Next, specimen of agreement to sell patents. Specimen agreement to sell patent rights. This agreement made on dash and dash between dash and dash first by and between first party patentee and second is assignee. So patentee is giving patent of the his innovation to assignee. So first, who is giving here? Patentee is giving to assignee. And patentee will give with some conditions to the patentee to use the patent. The patentee being inventor of dash, the innovation which he is into, that we have to write here. And holding patent rights, more specifically stated in the schedule 1 here too, is in exclusively manufacturing or marketing of product of several description sizes in the using the patented process. The assignee has approached the patentee in buying all the rights or interest of the patentee relating to the said patent rights. The patentee has consented to vend those rights to the assignee on terms and conditions hereinafter appearing. Now it is hereby consented as follows. Agreement to assign the patents to assignee. That in consideration of so and so to payable by the assignee to patentee, and for the payment dash the inventor, that is patentee, shall vend to assign all his right or interest with concerning the said patent rights. Deed of assignment. The patentee shall be executing an assignment deed and do all things as may be compulsory in vesting owing said patent rights in the assignee. Patentee's agreement. The patentee hereby agrees that as per the assignment of patent rights to the assignee, he shall correspond all progress made by him in said invention to assignee, and shall help assignee for doing all the acts, deeds, things compulsorily for procuring a patent for such progress, which shall be in the assignee and same term conditions as if such progress had formed portion of original invention. Assignee agreement. The assignee hereby agrees that as per assignment of patent rights to him, he shall not do anything resulting in the cancellation of said patent rights, and shall eventuality of such revocation pay to patentee as liquidated compensation. If he do any term violation, he has to pay the patentee such amount as a compensation. In witness whereof, parties here to have signed this agreement on the date here first here in above, schedule 1 herein referred to, and patentee's name, sign, signature. Assignee, patentee first because he is giving to assignee, patentee name, signature details, assignee name, sign, signature details, and 2 witnesses. And if required to register the patents will be registered with the controller of register of patents within the 6 months of transfer of assignee has to register. ADR, the process by which disputes between the parties are settled or brought to an amicable result without the intervention of judicial institutions and without any trial, without any intervention of judicial and without any trial is known as ADR. ADR offers to resolve all type of matters including civil, commercial, industrial and family, civil, commercial, industrial, family, civil, commercial, industrial, family, civil, commercial, industrial, family, etc., where the people are not being able to start any type of negotiation and reach the settlement. Generally, ADR uses neutral third party who helps the parties to communicate, discuss the differences and resolve the dispute. It is a method which enables individuals and group to maintain cooperation, social order and provides opportunity to reduce the hostility. ADR mechanism of dispute resolution that is non-adversarial, that is working together cooperatively to reach the best solution for everyone. ADR can be instrumental in reducing the burden of litigation on courts while delivering a well-rounded and satisfying experience for the parties involved. It provides the opportunity to expand the pie through creative collaborative bargaining and fulfill the interested deriving their demands. Types of ADR: arbitration, conciliation, mediation. Arbitration, conciliation, mediation. In arbitration, there are two: arbitration agreement or clause entered in the original agreement itself, in the dispute clause, like in the last while in the dates we have read now. In the case of dispute, parties may refer to arbitration or court, that is clause. And appointment of sole arbitrator, small d is there. Mediation, mediated settlement agreement, two dates are there, so total 4 related to types of ADR. Agreement of reference to sole arbitrator. This deed agreement is made on dash and dash between first party and second party, that is the parties who are in the dispute, first party, second party. And here means first party is not giving anything to second party is neither not receiving anything, so either of the format we can write just first party, second party, enough. Whereas the first and second parties have some dispute regarding the management of the partnership business. So first partner, second partner we can write, so they have written first party and second party. Whereas both the parties have agreed upon refer to dispute to one arbitrator duly appointed by both parties. Now this deed of agreement witness as under that the both parties have agreed upon to appoint Mr. Dash, son of Dash, resident of, as an arbitrator. That both the parties appoint as an arbitrator, that the arbitrator will go through the partnership deed and decide the dispute between the parties under the provision of partnership deed. That this deed shall be confined only up to dispute of the management of the firm. First party, second party sign, witness sign. Agreement to reference to common arbitrator. This agreement is made at dash between Mr. A, son of residing at hereinafter referred as first party, second party, and next, whereas by an agreement, building contract dated dash entered into between the parties. Here too, party of the first part entrusted the work of constructing a building on his plot of land situated at dash to the party of second part. So first party gave a contract to build the building to the second party on the terms condition mentioned. The second party has commenced the construction of a building according to the plan sanctioned by the municipal corporation and has completed the construction of the extent of first floor level. The party of first part has made certain payments to party of second part on account, but the party second party is pressing for more payments, which according to the party of first part he is not bound to pay. So according to the work second party performed, first party has been paid. Second party is feeling that the payment is not sufficient enough, and therefore the work has come to standstill. So he stopped working. Disputes have therefore arisen between the parties here too regarding the interpretation of a certain provisions of the said agreement, and also regarding the quality of the construction and delay in the work. Delay means he not paid, so he stopped the work, that caused the delay. And whereas the said agreement provides that in the event of any dispute or difference arising, the parties shall be referred to arbitration or common arbitrator if agreed upon otherwise two arbitrators, and arbitration shall governed by the provisions of Act. The parties have agreed to refer all the disputes regarding the said contract to Mr. Dash Architect, a common arbitrator, and have proposed to enter into agreement for reference of disputes to the sole arbitrator of Mr. Dash. Now it is between the now it agreed between the parties here to as the following point of dispute arising out of said agreement date hereby referred to sole arbitration of said for his decision and award. The points of dispute where the second party has carried out work according to sanction plan, second party has delayed the construction, where the first party of the second party is overpaid for the work done up to now, whether the second party is overpaid, whether the first party is bound to make any further payment over the above payment made up to now for the work actually done, all other claims of one party against the other party arising out of said contract up to now. The said arbitrator shall allow the parties to file their respective claim and contention and file documents relied upon by them within such reasonable time. So first submit the documents. The said arbitrator will give hearing. So hearing either personally or through respective advocates. So they themselves can come or through their advocates. But the arbitrator will not be bound to take any oral evidence, including cross-examination of any party. So oral evidence he can't take, only documents and records. Oral evidence, no. Big no. The said arbitrator shall make his award within a period of 4 months from the date of service of a copy of this agreement on him by and any of the parties thereto, provided that. So on the day he submitted this copy of agreement to the parties, from that day in 4 months he has to complete. The arbitrator will have the power to extend the said period from time to time with the consent. If within 4 months cannot make it, with the consent of both the parties, he can extend time. The arbitrator will not make any interim award, only final award, only interim award will not be made, only final award will be made. The arbitrator will have the full power to award or not to award payment of such cost of and incidental to the arbitration by one party to other as he may think fit, subject to provisions of Act. The award will be binding on the parties hereto. The arbitration shall be subject to what is herein provided by and governed by the provisions of Arbitration and Conciliation Act. In witness whereof the parties have put their respective hands, written and signed, Mr. A and B, that is parties, in presence of witnesses 1 and 2. Next, model arbitration clauses in an agreement means in agreement they will put the agreement arbitration clause. Now that model arbitration clause, this is a model how an agreement clause arbitration clause should be there in the agreement. Every dispute, difference, question which may at any time arise between the parties hereto are or any person claiming under them touching or arising out of in respect of this agreement or the subject matter thereof shall be referred, means any dispute, any discrepancies, any claiming amount, that all will be referred to arbitration of X by etc. Or if he shall be unable then or unwilling to act to another arbitrator to be agreed upon. So they have given the name also, arbitration of X, Y, etc. If not available or not okay, then another arbitrator also to be agreed upon between the parties, or failing agreement to be nominated by the so and so. Failing agreement, to arbitrators, one to be appointed by each of the parties. Party A will appoint one arbitrator, party B will appoint the other arbitrator. To the difference. And in case of a difference of opinion between them, to umpire the appointed by the said two parties, means two arbitrators appointed by party A one and party B second one. So these two arbitrators together they will appoint the another third arbitrator before entering on the reference on their decision. In the event of any dispute, difference, question thereof, compensation, any manner whatsoever in connection with the same shall be referred to Chamber of Commerce for the arbitration provided in rules framed by the said chamber. This decision or award so given shall be binding on the parties. So if they have any discrepancies or default, they will go to the Chamber of Commerce for arbitration, and the award which came in that arbitration shall be binding. All disputes arising between the partners as to interpretation or operation or effect of any clause in this deed or any other differences arising between the partners which cannot be mutually resolved shall be referred to arbitration of dash, failing him to any other arbitrator chosen by the partners in writing. The decision of such arbitrator shall be binding on the partners. So, the decision of arbitrator is binding on the partners. Model conciliation clauses, where in the event of any dispute arising out of the parties wish to seek an amicable settlement of the dispute by the conciliation shall take place in accordance with the. So for arbitration also same matter we can write, only we can replace the word conciliation with the arbitration. If any dispute arises between the parties out of relating to this contract or in respect of any defined legal relationship associated therewith, the parties agree to refer to the same to the sole conciliator for the amicable settlement. For sole, the conciliator shall be appointed by the parties by mutual consent of the two parties to the contract. If the parties shall fail to arrive at an agreement, if they fail to appoint mutually one person as an conciliator, the conciliator shall be appointed by institution. So, model arbitration clauses in agreement is like they will be referred to the arbitration. In the clause, in default clause or dispute, in dispute clause it is mentioned that in case of any dispute or anything problem, they will be referred to the arbitration of X and Y, and if they are unable to, unwilling to act to another arbitrator to be agreed upon between. So, they together in the agreement provided that Mr. A will be the arbitrator. Now they don't want Mr. A, so they can appoint Mr. C as an arbitrator, and in second they shall be, if any dispute, it shall be referred to the Chamber of Commerce for arbitration, and the decision will be binding on the parties. And in case of arising any dispute arising in with respect of interpretation, operation and all, the partners, if cannot be mutually resolved, shall be referred to the, if they themselves mutually cannot resolve, they will be referred to the arbitration of, failing him to any other arbitrator chosen by the partners in writing. The decision of such arbitrator shall be binding on the partner. Means if parties are unable to choose the arbitrator will choose the another arbitrator, that will be binding on them. And model conciliation clause, dispute will be referred to conciliation and to seek the amicable settlement that by the conciliation and in accordance with the act will take place. And both parties together agree to appoint a sole conciliator. If they fail, with the mutual consent to appoint, the conciliator shall be appointed by the institution. Model mediation clauses. So in the clause of the OG agreement only, mediator has been identified. Then that mediator only will be appointed as a that mediator only will be appointed for the proceedings in the mediation. If in future they don't want him, and they can replace also. If he is not doing he is doing any bias, anything, if parties are not satisfied, they can replace. And cost will be shared by each parties equally, and mediator has to do according to the act, rules and regulations. And mediation involves no formal court proceedings or rules of evidence, and the mediator does not have the power to render a binding decisions or the force an agreement on the parties. So just he can amicably settle the things. No, this will be not binding, whereas arbitration is binding on the parties. Where mediator has not identified in advance the agreement to be mediate disputes. In the event of any dispute arise between the parties in relation to agreement or out of this agreement, and the dispute is not resolved by the negotiation, the parties agree to submit the dispute to mediation. The parties further agree that their participation in the mediation is a condition precedent to any other party pursuing any other available remedy in the relation to dispute. Any party to the dispute may give a written notice to the other party of commencement of mediation. So before only not then if A want to initiate, he want to give notice to B that I want to initiate the mediation, desire to commence mediation, and a mediation session must take place within 30 days after the date of such notice is given. The parties must jointly appoint a mutually acceptable mediator. If they are unable appointment of a mediator within 7 days of a party giving notice, any party may apply to organization for mediation or any a person agreed by the parties in writing If they are not able to, within 7 days they can make an application to organization for mediation. They will appoint, and the parties further agree share equally to the cost of mediation, which cost will not be include the cost incurred by party for representation by counsel. Mediation agreement. This is an agreement between hereinafter referred as parties and hereinafter referred as mediator. Mediation agreement is between, till now what and all we have read is between the parties itself. This mediation agreement is between the parties, that is A and B, and mediator entered on dash. Whereas the purpose of this agreement is to enter into mediation with the intent of resolving all the issues regarding the parties, and the mediator understand and agree as follow. First, nature of mediation, that mediator will help the parties to solve. He can give the legal advice, and the parties also understand that the mediator has an obligation to work on behalf of all the parties, and the mediator cannot render individual legal advice to any party and will not render any remedy nor arbitrated within the mediation. The parties hereby appoint and retain dash as a mediator for their negotiation. The parties understand that mediation is an agreement reaching process in which the mediator assist the parties to reach the agreement in a collaborative, consensual and informed manner. It is understood that the mediator has no power to decide disputed issues of the parties. The parties understand the mediation is not a substitute for the independent legal advice. Scope of the mediation. The parties understand that it is for the parties with the mediator's concurrence to determine the scope of the mediation, and this will be accomplished early in the mediation process. Mediation is voluntary. Either of the party can withdraw. Even mediator also can withdraw the mediation. If any, the parties also understand that mediator may suspend or terminate the mediation if the mediator feels that the mediation will lead to unreasonable result. If the mediator feels that an impasse, that is impossible, have been reached, if the mediator determines that he can no longer effectively perform his facilitative role, then the mediation can be cancelled, that is withdrawn. So first party and second party and mediator additionally and witnesses. Specimen mediated settlement agreement. See, now mediation agreement happened now. In that that agreement becomes successful and parties have okay with the issues solved. What and all issues solved, who and all should do what acts, that will be agreemented in this form. So like example, Mr. A has to do certain act and Mr. B has to pay the damages and Mr. A have to deposit amount. Like this list of activities to do good things, in the mediation will be settled. That things will be done or no, who is guarantee? So this all has been settled in the mediation agreement. Here this is the mediated settlement agreement, that we are into settlement now. These are the terms we are okay with in the mediation agreement. Specimen mediated settlement agreement at New Delhi. First party and second party, various pursuant to agreement dated dispute arose, and by virtue of above said, the parties mutually agree to settle their disputes through mediation by entering into separate mediation agreement as mediator for conduct the proceedings. Now hereby witness it now it is hereby agreed as the parties to this agreement accepts and agrees to the terms and conditions and clauses as full and final settlement of their claims made by the first against second pertaining to matter indicated in the mediated settlement agreement. So they have accepted the terms and conditions. The second party agrees to pay so and so amount during the duration between. So in this time I will pay the consideration or amount for the 100 computers, and first party agreed to provide annual maintenance of for the said computers free of cost for a period of 3 years. So A is giving computers to second party. First party is giving 100 computers to second party has to make payment for that, and the first party will along with computers for 3 years freely it will provide annual maintenance, but the first party shall made available one of its employee during the office hours of the second party, and one of the employee will be made available in the office of second party, and the employee of the first party shall be entitled to earned leaves per month. So conditions or terms of the employee, that also will be taken care by the second party, because for second party he is working. Only the employee will be provided by the first party. The payment shall be made by the second party to the first party by online transfer in the bank account of later, that is first party, by account pay check, because he purchased 100 computers. For that he has to make payment. The parties agree that unpaid amount cut-off date for making means for credit transaction will give last date. By this you have to make payment. That date they are talking about. If after that date also they not paid, we will charge the interest at 10% compounded quarterly time to time. The party agrees that there shall be no further penalty or claim made pertaining to the transaction between the parties. It is agreed between the parties that all the liabilities of the second party for the payment as mentioned in the letter of the possession dated are inclusive in the above agreed amount 25 lakhs, and no other payment whatsoever would be payable by the second party. Means only 25 lakhs I will pay, no any extra amount. Except interest. If he made the delay in the payment, he has to pay the interest. And first party gave annual maintenance services for 3 years free. So after 3 years, that is after 1/8/2021, for maintenance also second party has to pay. The parties agrees that parties shall pray the honorable court for suitable adjournment of the proceedings, so that the parties can ensure compliance of the terms of this agreement and thereafter jointly apply to the honorable court. It is agreed between the parties that parties shall pray to the honorable court for the suitable adjournment or both the appeal of the two appeals of the aforesaid. Like this is a mediated one. If after this they want to go for any appeal, they have to go to the honorable court. And remember, any case if it goes to court or civil court, criminal court, whatever, at last, that is in the edge of the deed, the parties has to ask for the prayer. Means we request you, pray, our pray is this, we want this, pray clause should be there. Only then the High Court will give any what they have prayed for. If they not pray, they will not get anything. In witness whereof the bank through its authorized officer has set hand and stamp on this. And first party, second party, mediators, sign signature. Employment contract, that is like a CS. In CMADT there is like a CS appointment related agreement. Same this is also. Employment agreement is an agreement that is entered into two parties, that is employer and employee. It is a document that describes the responsibilities and duties expected of an employee. It also describes the profile of the job and the title. The document ensures the employee knows his place in the organization and what is expected of him. Employment agreement should be created in a way that is just and fair for all the employees. If this is followed, employees will do their task and responsibilities well and without any negative emotions toward their employees. Employee A and employee B. For employee A, more favor, and for employee B, less favor. If like that is a discrimination will be started. So all the terms should be similar for all the employees for the same work they are performing. In same work, any discrimination shown means they will get less interest to work. The employer should provide the employee with all of the company policies and other docs that relate to the contract or refer to the employment referred to in the contract. Following are the usual contents of the employment agreement. So even if you remember this, you can write on your own. First, name of the parties involved, employer and employee. Starting date of the employment, that is in case of listed offer letter. And title and description of the job. Title, like title CS, description to look after the compliances in non-financial matters and all. Location of the work, from office or from remote, like work from home. Hours of the work, 8 hours, 10 hours. Probationary period, salary, restricted terms, holidays, other information like deduction, permissible acceptances, notice period, etc. Employment agreement, certain important issues that need to be taken care of before finalizing the employment agreement are given here under. Identify the long-term requirements of the employees. Identify the long-term requirements of the employees. Identify the workman and employee not covered under definition of the workman respectively. Local laws of the state, issue appointment letters, employment contracts depending on the requirement. Use fixed term contract for the workmen. The terms and conditions of the employment should be clearly explained to the employees before executing and should be drafted without any ambiguity. Settlement agreement. A settlement agreement is a legal contract that resolves the disputes among all the parties by coming to an agreement. It is a legal doc where all the parties in a court in civil agree to outcome of any judgment being made in advance. What is the purpose of settlement agreement? Here are some situations in which settlement agreement can apply. First, any property damage claim, mediation or conciliation settlement agreements, corporate settlement agreements, family business settlement, and employment disputes. How can you prepare for a successful settlement agreement? How can you prepare for a successful settlement agreement? Understanding the potential terms and researching them will get you ahead in the settlement agreement process. You can start by looking at any terms that would assist the case in mediation process. Here they gave for family business settlement. The deed of family arrangement executed on dash AB son of MN aged, and here in the first part, and CD son of aged, whereas the first party has started and carried out the business. First party has started the business and carried out a business and undertaking described in Schedule A by his own initiative and efforts with his own capital and funds. The second party, who is son of predeceased son of the first party and residing with him under the care and parentage of the first party, and assisting him in the conduct of the aforesaid business, for which he was being paid share in the profit. The second party, thus having contributed his labor and skill for the development of the business, rendered valuable services for the same, and rendered himself entitled for an equal share. So he is asking for equal share in the said business. It has been settled and decided to distribute the business among the parties, so also the properties. So property and business both is getting distributed equally. The first party shall hold the share in the business and properties described in the Schedule B, and the second party shall hold the shares in the business and properties described in the Schedule C. So both will hold the shares and both will hold the properties. Property A is for first and property B is for C. For second party. The mobile and immobile property, which also described in Schedule A, have been acquired by the first party out of the funds of the said business in his name and for use and benefits. Now this deed witness it as follows. The second party shall hold, own, possess as full and absolute owner of the businesses and properties described in the Schedule C, without any demand or claim of the first party. So like younger brother will take property of A without any claim of older, and older bro will take jewelry without any claim of younger, rest between the equally, like that we can write. And in witness whereof and signature of the first, second, and witness, two witnesses. Drafting of bylaws of the society. A society may be defined as an association of persons united together by mutual consent to deliberate, determine, and act jointly for some common purpose. Where a charitable organization intends to have an open participation of a large number of people in its functioning and decision making, it must be registered as a society. Societies have been envisaged as a welfare and charitable associations of the people having a broad base membership and comparatively more democratic and transparent setup as compared to such setups as a public charitable trust. The following societies can be registered. And specimen, name of the society, specimen, format of a memorandum of association and rules. Okay, first, memorandum of association of so and so charitable society. First, name of the society and its registered office, and aims and objectives, what and all aims and objectives are there, and to achieve that aims and objective, who will do work, governing body, and who consist, means who are the part of the governing body, that list. And desirous persons, we understand, are desirous of forming a society, namely under the society in pursuance of, so even these people want to form part of the society, that list. Next, and all the income earning movable property of the society shall be utilized and applied towards the promotion of its aims and objectives of in the mentioned in the MOA and AOA. And no profit on there shall be paid or transferred directly or indirectly by way of dividend. So no bonus, no dividend, nothing. Attested signature of form number 127, signatures of two witnesses other than the members of the society and addresses. Signature of the attesting officer with official seal, certificate that this is true and correct copy of memorandum. Signature of any three members of the governing body, president, secretary, and treasurer. And rules rules and regulations of charitable society. Like just now we gone through the deed now. On the in respect of a deed only, they gave further elaboration and extension of the points, like name, address, membership. In membership, lifetime membership fee how much, annual membership how much, or monthly subscription how much, and admission of a fee of each member. Means to admit a person as a member of the society, what is the fee they are charging, membership fee. And eligibility, who has attained 18 allowed to become a member. Like that extra masala they have given, we can write on our own. And executive committee, like in discharging the functions of any society related and promoting the objectives and all, they will work. And at last, general secretary also they gave, like they will call for meetings, general and special body meetings, and shall be correspondent to the association, and shall be in charge of the office with all the records. Means they will maintain the records, and shall be custodian of the all articles, and shall operate bank account jointly with the president. Signature of any 3 members of a governing body. Next, drafting of standing orders. The act make it obligatory for the employers of an industrial establishment where 100 or more workers are employed to clearly define the conditions of the employment. 100 or more for if employees or workers are employed in the establishment, then they have to draft a standing orders for the workers by way of standing orders, rules, and to make them know the workmen employed. However, in city of Delhi, the act applies to industrial establishments where 50 or more, normally 100 or more, but even 50 or more also applied in the preceding 12 months. The employer is required to prepare a draft standing orders which he proposes to adopt and submit the same to certifying officer. So employer has to make a draft and submit to the certifying officer for certification. The employer is required to act in conformity with the certified standing order. So what standing orders got certified by the certifying officer, according to that only employee should act in dealing the day-to-day affairs of the workmen. Certified standing orders have the force of law like any other enactment. All deputy labor commissioner of the labor department have been appointed certifying officers for the purpose of certification. Penalty. The act provides that in case of an employer fails to submit the draft, he shall be 5,000 can be imposed, and in case of contravention of standing orders, means first like he failed to submit a draft, for that 5,000, and contravention, he submitted the standing order and contravened, then fine up to 100, and in case of continuance of offence, fine up to 25 for each day, 125. So short title and definitions like Aadhaar, code, form, habitual, standing order, classification, permanent, temporary, apprentice, probationers, fixed term, permanent, and all they gave. And identity badge or card, like card they will give now, ID card, and publication of working timings, for how much time they have to do working timings, and publication of holidays, pay days, and wage rates. How they'll determine the wage rates and pay days, and publication of holidays, publication of wage band. Wage band payable to all categories of workers shall be displayed on the electronic notice board and website or human resource portal. Shift working, like day shift, night shift, or OT, that all related stuff. Notice of change in the shift working. That notice shall be displayed on the conspicuously by the employer on a notice board. Work from home option, if is there or no, if is there, what time and how they can perform. Attendance and late coming, leave, holidays and leave cannot be claimed as a matter of right. No employee while on leave shall take up an employee and any employment, any vacation of profit or gain. Casual leaves, payment of wages, service records, confirmation, age of retirement, at what rate they can at what age they can retire from the work, transfer, medical aid in case of accidents because of working conditions, or while in working any accident met, or normally accident any outside the work. For both, how will they treat? Secrecy, exclusive service, stoppage of the work, termination of employment, in which cases they will get termination, disciplinary action for the misconduct, other rules. Done. Next, reply to show cause notice. Reply to the show cause notice sent by the court. If the court send any show cause notice, the person to whom such notice is given must give his in the highest priority. So the points to be kept in mind while writing a writing a reply to the show cause notice. First, a proper explanation has to be provided at the earliest. It should be kept as a brief as possible, means in lesser words or in lesser para. It must be written in such a manner that the court is satisfied with the fact that he or she is aware of the gravity of the situation. Some more points to be kept in the mind. When you're filing a reply to the show cause notice, it must be always kept in mind that you must give a reasonable excuse. Any individual must draft his or her reply in such a way that if a layman would read it, should find the same as reasonable. Notice under Negotiable Instrument Act. According to 138, where any check drawn by a person on account maintained by him with a banker for the payment of any amount to another person from out of that account discharged and the account is insufficient to honor the check or exceeds the amount arranged, means the dishonor of the check. So the such person shall be deemed to have committed an offence and shall, without prejudice to any other provision of the act, be punished with the imprisonment for a term which may extend to 2 years, or fine which may extend to twice the amount of the check or both. So 2 years or twice amount, provided nothing contained shall apply. If means no imprisonment or no fine. If deposit check means the person who has to deposit the check, he has to deposit in the time. If within the time if he not deposit and check got dishonored, that is not the mistake of the check given person, right? So within 6 months he has to deposit the check, within 6 months or the validity date mentioned on the check, whichever is earlier. In that only he should present. After date, if he present and saying that check got dishonored, so I want him to be punished, then it is not going to work. And the pay should make a demand for the payment of the said amount within the 30 days of the receipt of the information by him for the bank regarding the return of the check. So now bank has been returned the check. Within 30 days that your bank has been returned me the check, bank has been returned the check, I want the payment. See, payment has not done. Within 30 days he has to make a demand for the payment. If not done, then he cannot ask, the check issued person cannot be punished. The drawer of such check fail to make payment of the said amount, as the case may be, to the holder within 15 days of receipt. So within 30 days the payee gave the notice, but within 15 days from the payee gave the notice, he has to make the payment. He not paid, then also he will be liable. And notice under 138. This is same as circular, like if you remember circular it will be easier. So legal notice dated to name X, address and section and subject. Notice under 138, under the instruction from and on behalf of my client, that is lawyer writing, no? So he will mention this line. So you have purchased goods on the credit for 6 lakhs and approach and demanded the same, and client, in consideration of having a good business, after 10 months my client has approached to you to make the to said notice to return above said amount 6 lakhs, then the noticee demanded some more time. So after 10 months I asked you for the payment and you have demanded still more time, and after the completion of 1.5 month to you noticee, and the noticee has been given 1 lakh in cash and issued check respectively. You gave the cash and check also you gave, and check drawn on Bank of India and in favor of my client, and that at that time the client has asked you about the remaining balance of amount 3 lakhs. The noticee again assured my client that I will repay in the near future, and as per your permission my client presented a single check of 1 lakh. However, utter dismay to my client that above said check is got dishonored for the reason of insufficient fund, and that after the dishonor of the above check my client sometime approached to you to the noticee, but you have not returned the above said check of 1 lakh to my client, and you have required to take a notice of demand under 138 and to pay the amount within 15 days from the receipt of this notice, failing which you shall become liable to be prosecuted under the penal. And if it is therefore call upon you through this notice to pay the check of 1 lakh along with the council fee of 1000 to my client within 15 days, and in the eventually if not paid, proceeding to the show cause, you have to suffer the cost and consequences, and keep a copy kept for the further actions necessary. Yours sincerely, advocate. And the other party will reply to this notice through his legal advisor. Reply to the notice and name of the advocate, and advocate details, phone number, date, to subject replying to the notice under 138. Dear sir, your notice have been placed before our client at a place in New Delhi, and I undersigned and have been interested to been instructed to reply to the notice. And here either we can deny or accept as per the para. In they also gave in parana, you approached, we gave credit, cash payment, and after 10 months, like how para wise they gave na, in para wise only we have to accept or deny. That at outset you are being informed that the notice under reply you have sent content false. So the notice contains a false fact and unconditional apology by your client that my client did not place any order, so he not placed at all order, but with a view to dispose of your old stock or outdated mission, you requested my client to place them at his shop. So your client has asked our client to keep the goods, so our client has been showed mercy and kept. We not placed any order. If you want, you take back your goods. Those are lying in the godown of a client, and however your client has cheated my client by misusing the check which is not handwritten of my client. As a fact, your client has committed fraud in the matter and consequently is liable to proceed under relevant provisions. That therefore it is denied that the check is question was issued by my client to your client in discharge of any liability. Rather, your client has misused the blank check with fraud motives, forging the same. So reply on merits that the wrong and denied whatsoever stated above, and it is denied that my client purchased from your client, and para 2 also denied. Para 3 of the legal notice what stated submitted your client was not entitled to use the check. He is not at all entitled to use the check, and are denied for want of knowledge, however, that any check was issued in the discharge of any liability toward my client, and the content of para 6 no need comments, denied. And in the view of aforesaid facts and circumstances, you are being advised to further advise your client to withdraw the said notice under reply, and further advise him not to drag my client into frivolous litigation, failing which my client shall constrained to contest the same besides proceeding against your client. Yours sincerely, advocate. Next, tips to improve drafting of legal docs. Keep readers in the mind. Keep readers in the mind. Jot down points prior writing. Jot down the points prior writing. That is recitals or a synopsis. Avoid formal and technical terms. Avoid formal and technical terms. Avoid formal and technical terms. Keep writing to the point. Keep writing to the point. Keep writing to the point. Two keeps are there. First one keep is keep readers in mind. Second keep is to keep the writing to the point. And avoid formal and technical terms. Active voice brings clarity on the subject. Be careful when you edit. Be careful when you edit. So we are done with chapter 4. Thank you. Happy learning.